My name is Lydia Quinta, and I am a principal consultant with the multilingual department at the Illinois State Board of Education. And the presentation I would like to offer to you today covers educational rights and responsibilities of dually identified students, and it is meant as a guide to parents and guardians. Some of the topics included in this presentation are definitions, child find, MTSS, or multi-tiered system of supports, referral and evaluation, eligibility categories, IEPs or Individualized Education Programs, least restrictive environment, and English learners with IEPs in transition programs. Let's start with those definitions. English learner is a student who qualifies for supports during acquisition of English language at school and who has been identified based on the home language survey and a screening process conducted by the school district. Student with a disability is a student who has been evaluated for special education services and as a result of that evaluation has been found eligible for special education services under one or more of the disability categories identified under the federal law known as IDEA, and both terms are going to be explained further in this presentation. In 2015, the Civil Rights Division of the U.S. Department of Justice and the Office of Civil Rights in the U.S. Department of Education issued a letter stating that some school districts have either formal or informal policy of not providing dual services. Some districts may also have a policy of delaying evaluation for special education services until a child speaks better or speaks fluent English. Now, those policies are not permissible anywhere in the United States under current federal laws. Whenever the student is identified as an English learner with special needs, a school district has to provide services in both areas, the language support and the special education services. If you believe that your child who is an English learner also may have a disability, the public school district must not delay your child's evaluation for special education services only because your child does not speak fluent English or does not speak English at all. If the district is trying to convince you that it's best to wait a few years and do that evaluation when your child's English is better, it is not only impermissible under the federal laws, but also under the state laws in Illinois, and that approach is simply incorrect. If a child is suspected of having a disability, the evaluation should happen as soon as possible, regardless of that child's proficiency in English language. However, sometimes we are dealing with the opposite situations when a school district is telling parents that a child should be evaluated and receive special education services only because the child has limited English proficiency. The fact that a person does not speak English or that a person does not speak fluent English is not a disability. And arguments that special education services will provide additional support, that they might help your child who does not speak fluent English, are simply incorrect, because special education services were never meant to address limited proficiency in English language. If your child is in fact an English learner, those supports should be provided through bilingual education and not through special education. Sometimes there are instances when a child who is an English learner struggles academically, and it's really hard to say whether it's because the child does not speak English or maybe there is a disability that should be addressed. In those instances, the best approach is to implement MTSS, which is the multi-tiered system of supports. The first level, or the first tier, it's called universal instruction, and it is available to all children who struggle academically, regardless of the fact that they are English learners or they are fluent English speakers born and raised in the United States. If those interventions do not work, a child is moved to Tier 2, which is targeted group intervention. At this level, your child will work with a smaller group of students, and interventions will be designed specifically for those students. If after a while the child is not making progress, the child may be moved to Tier 3, which is intensive individualized instruction, which is most similar to special education services, but again, it's available to all students who qualify for this level of intervention. At this tier, the child is either going to work one-on-one with the teacher or is going to work with a very small group of 2-3 other students who have similar difficulties, and they will work with specialists, with teachers who know how to design interventions that are appropriate at this level. The MTSS process should start with assessing your child's dominant language literacy skills, followed by establishing similarities and differences between that language and English. And this knowledge should be used in designing all 3 levels of MTSS interventions. For example, if your child is a Spanish speaker and your child can fluently read a Spanish text but cannot read an English text, there is a pretty good chance that the problems are linguistic and have nothing to do with a disability. Also, if your child is coming from a phonetic language background like Spanish or Polish, the child may be unable to pronounce those unique sounds in English language, which again is related to differences between languages and not to a disability. If your child is an English learner suspected of having a disability, your child must be evaluated in his or her dominant language. The main language that your child is using, the language in which your child is most comfortable. Also, that evaluation has to be non-discriminatory and respectful to your child's culture. Your child's status as an English learner and your child's proficiency in English must not delay that evaluation, which I have mentioned before and which is really very important. Your child's evaluation for special education services should include documents from your child's country of origin translated into English if you have any documents available. For example, if your child attended school in another country and was already identified in that country as a student with special needs, you may want to provide that documentation. If you have a medical diagnosis from another country, that's another document that would really be useful in evaluation in the United States. Also, your child's evaluation should include observations in different environments, because a child who is an English learner may act differently at home when he or she feels safe and secure, and at school where he or she is surrounded by children whom your child cannot understand. Finally, and that's probably a crucial element, the evaluation should include an extensive interview with you and possibly other members of your family. That interview will have to establish your child's health history, milestones in his or her dominant language, and functioning when compared to siblings, to other relatives, and to children who belong to the same group, which means children who are more or less the same age, who speak the same language as your child and who represent the same culture as your child. If you or other family members involved with the evaluation do not speak fluent English, all communication should be conducted with a qualified interpreter. That interpreter must be provided by the school district, and all costs related to his or her work must be covered by the school district. Evaluation of an English learner for special education services should include additional aspects or additional elements. For example, the evaluator, usually it's a school psychologist, other school personnel, sometimes an outsider who speaks your child's dominant language. So that person should use instruments appropriate for assessment of performance in your child's dominant language. Obviously, the evaluator would like to know how well your child is going to perform when language is not an issue. Also, that evaluator should consider your child's progress in bilingual education, for example, in classes that are taught in your child's dominant language, and also in classes with bilingual support. The evaluator will have to make a decision what other information and what other data will be needed to make a decision whether a child has special needs, and also that person will have to avoid reporting any scores if norms were not appropriate for English learners. To give you an example, if a child recently came to the United States from sub-Saharan Africa and the test requires the child to describe a snowstorm, that task will not be performed because the child never experienced a snowstorm, and the results would be invalid and have nothing whatsoever to do with a disability. Finally, the evaluation should include representatives with expertise in bilingual education. Those would be people who might be able to tell the lead evaluator that certain behaviors are the result of the fact that the child does not speak English and not a consequence of a potential disability. Sometimes parents of a child with a disability may be frustrated with a public school district because they have a medical diagnosis for their child, and the public school district refuses to use that diagnosis as an eligibility category for special education services. If you are in that position, please do not be frustrated with your school district. They are only following the law. And the law says that a child to be qualified for special education services, that child not only has to have a disability, but it must be something that has a negative effect on your child's performance and requires specially designed instruction and related services for your child to make progress in the general education curriculum. And again, there may be medical diagnoses that have nothing to do with educational performance, and in those cases the child may not even be evaluated for special education services, or the child may qualify for services but under a different category than your medical diagnosis. Again, if your child is in that situation and the child does not qualify for special education evaluation, discuss it with your school district, and there may be other option available to your child, such as a 504 plan. As far as IDEA laws and eligibility categories in special education in the United States, there are currently 14 categories identified for students, and they are autism spectrum disorder, deaf-blindness, deafness, developmental delay, emotional disability, hearing impairment, intellectual disability, multiple disabilities, orthopedic impairment, other health impairment, specific learning disability, speech and language impairment, traumatic brain injury, and visual impairment. 2 comments. If your child does not speak English or does not speak fluent English, it does not mean that your child has a speech and language impairment. These are 2 very different things, and as I mentioned before, as I keep saying, not speaking English or speaking limited English is not a disability. Also, developmental delay is a category meant for really young children, preschoolers, children in kindergarten, sometimes the 1st grade, when it's really hard to say if the child has a different disability or the child is just delayed in his or her development, but may catch up with his or her peers. By the time your child is older, usually around the 3rd grade, that category is no longer used, and the child either no longer qualifies for special education services or qualifies under one of the remaining categories. Now, the fact that the child is receiving special education services does not mean that the child also qualifies for bilingual services, and vice versa. So let's talk a little bit about bilingual supports. A student can be identified as an English learner only when at least one question on a home language survey was answered yes. That was a document that you received when you enrolled your child at school, and that document included at least 2 questions. They were, is a language other than English spoken at home? And does your child speak a language other than English? If either one of those questions was answered yes, your child was screened, and Illinois is a WIDA state, which means that we are a member state of a consortium known as WIDA, and we are using WIDA screeners to evaluate students for bilingual supports. The selection of screener is based on your child's age. When your child is a preschooler, the district will use pre-IPT. When your child is between the 1st semester of kindergarten and the 1st semester of the 1st grade, it will be a WIDA model. And if your child is older, it will be a WIDA screener. And based on the score that your child receives on that screener, your child will either qualify or not qualify for bilingual supports, which again have nothing whatsoever to do with special education services. Before each IEP meeting, if your child actually does qualify for special education services, and those meetings must be conducted at least once a year, although they may take place more often than that. A parent or a guardian of a child with an IEP must receive a notice, a conference notice, which lists the purpose of a meeting, and you must also receive a document called procedural safeguards. A conference notice and a copy of the procedural safeguards must be provided to you in your dominant language, unless you specifically said that it is not your wish and you signed a waiver and requested that documents sent to you by the district should be in English. Information on your child's and yours primary language included on page 1 of the IEP document must be accurate and must be consistent with information that you provided on that home language survey that I mentioned before. If you, for example, stated that language spoken at home is Farsi, and that's your dominant language, but the first page of the IEP states that the only language spoken by you or your child is English, that's incorrect and should be immediately addressed. If your dominant language is other than English, the district must provide an interpreter for all IEP meetings, and that person must be listed with other participants' information on page 1 of the IEP document. Sometimes parents feel offended by this approach because they speak good English and they do not need an interpreter. Please do not be upset with your school district when it happens, because the district is required to provide an interpreter unless you followed the procedure that I mentioned before and you specifically requested that all communication between the school district and yourself should be conducted in English. When you did not do it, but you feel that your English is good enough, the interpreter does not have to interpret every single word that is said at the IEP meeting. The interpreter may just be present at the meeting, and you may only ask for explanation of some terminology or definitions that you are not familiar with, because they are specific to special education, and trust me, there is a lot of definitions and terminology in that field. Also, if your dominant language is other than English, the school district cannot ask you to waive the right to have an interpreter present, and they cannot tell you that, oh, your English is good enough, you don't need an interpreter. If you believe that this is the case, it has to come from you, not from the school district. If your child is an English learner with an IEP, it is advisable to invite a bilingual specialist to your child's IEP meeting. While that person may not be familiar with special education, it is someone considered an expert in bilingual education. It is someone who probably works with English learners on a daily basis and will be able to provide other members of the IEP team with valuable information on behaviors that are typical to English learners and not necessarily related to a disability. Your child's IEP must also include other information if your child is an English learner, such as your child's communication needs and current level of performance in both English and your child's dominant language. Also, it must list appropriate linguistic and cultural accommodations that your child might need. And finally, it is required that it includes information on access or alternate access exam, and list accommodations that your child should receive during testing. And access or alternate access is an exam that all English learners must take once a year until they no longer need services, and based on this score are no longer considered English learners. All students with IEPs, including English learners, all students that attend school have the right to the least restrictive environment, which means that they have the right to spend as much time as possible with non-disabled peers. An English learner with an IEP who, based on access, that exam scores should be placed in a full-time TBE, Transitional Bilingual Education Program, can be moved to a part-time TBE program when the IEP team believes that it will increase that child's participation in the least restrictive environment. Again, the purpose here is to make it possible for your child to spend as much time as possible with children who do not have any disabilities. The IEP team does not have the right to waive bilingual supports at school. They cannot say that special education services trump bilingual supports, and therefore only special education services should be provided. That is not allowed, and it's simply wrong. The team could not also suggest it to you. They cannot coerce you to refuse bilingual services. And finally, they cannot say that bilingual supports to your child who qualifies as an English learner will only be provided through consultation between teachers. Bilingual supports are direct services, and your child should work directly with a qualified teacher. Let's talk about older students with IEPs who are in transition programs. Some students, and it usually applies to students with more profound or severe disabilities, can stay at school, and I'm talking about high school, until the day of their 22nd birthday. They do not take academic classes anymore. They are done with those requirements, but they need other services from the school district. And if your child belongs to that category, for example, a child has severe autism and came to the United States when the child was 18 years old and is done with academic classes, the child may still have linguistic or language needs, and that child will receive bilingual supports for as long as that child is attending school. If they don't attend any academic classes anymore, why do they go to school? Because they may be in a life skills program. They may be in a vocational program. Let's not forget that we are talking about young people with severe, profound disabilities who still need to learn skills that will be useful in their future life. If they do not take any academic classes anymore, they do not have to take access exam or alternate access exam, but as I have mentioned earlier, they still qualify for bilingual supports. This concludes my presentation. If you have any questions related to dually identified students, students who are English learners and also have a disability, or if you have any other questions related to bilingual education, feel free to contact us at multilingual@isb.net. And if you choose to send us an email in your native language, we'll do our best to translate it and to respond in your language. Thank you and good luck with your child's education in the United States.